I've just taken out of the book some pretty basic key terms for torts that should be memorized. What are the elements of defamation? That there's a defamatory statement of and concerning the plaintiff, publication, damages, falsity, fault, and defenses, or a lack thereof. So a defamatory statement of and concerning the plaintiff is publicized, and the plaintiff establishes damages, or doesn't have to because it's libel per se or slander per se. Falsity, fault, which isn't always necessary. But if it is, in the constitutional analysis, would be pertaining to a public figure or a public concern is being spoken of, and the speaker acted with knowledge that it was false, maliciously or recklessly, did not determine if that information was false before publishing it, and then defenses, which could be consent, absolute privilege, or qualified privilege. So I know I have actually recently defined qualified and absolute privilege. It's like one of those things people don't even define in their essays. Yes. So state and federal legislators acting in their capacity as legislators have an absolute privilege for what they say on the record of the floor of the legislature. It offers them a cloak to shield from defamation liability. In other words, ordinarily, they will not be liable for defamatory statements. The absolute privilege is not affected by showing of malice, abuse, or excessive provocation. So they don't have qualified privilege here. Let's move on to the privacy torts of misappropriation, where the defendant uses the name or image for commercial use without consent. There's an exception for newsworthiness. Intrusion is an invasion of the plaintiff's seclusion in a place the plaintiff reasonably expects privacy in a way that would be highly offensive to a reasonable person. There's no defenses, at least in my table, for this. For the defendant to argue against being held accountable for intrusion, false light, dissemination of material falsehood about a plaintiff that would be highly offensive to a reasonable person. Again, the same defenses I just gave of consent, absolute privilege or qualified privilege for false light, dissemination of falsehood, material falsehood, and publication of private facts is a widespread dissemination of confidential information about the plaintiff, which is not of a legitimate concern to the public, with, again, the same three privileges. For the basic intentional tort rules, assault is a reasonable apprehension by the plaintiff of an immediate harmful or offensive contact with his or her person. Battery is a harmful or offensive contact with plaintiff's person. False imprisonment, an act confining the plaintiff to a bounded area. Intentional infliction of emotional distress, extreme and outrageous conduct causing a severe emotional distress. Trespass to chattels and conversion is an interference with plaintiff's possessory right. Intermeddling will just result in damages or dispossession. Like a forced sale would be more of that, of conversion. Trespass to land, a physical invasion of the plaintiff's land. Nuisance, a substantial and unreasonable interference with the use and enjoyment of property. public or private nuisance are discussed. I have a lot of the basic definitions on the board on the wall behind me, and I wrote this many more. So I might as well use this time to go through them. That's probably why I'm so depressed. Slander per se is a characterization applied to certain categories of spoken defamation. If defamation falls into one of these categories, injury to reputation is presumed without proof of special damages. For example, business, trade, professional ability or abilities of business, trade, or profession, loathsome disease, unchastity, and moral turpitude will arise or will be considered slander per se. Again, the plaintiff will, their damages are presumed without proof. Informed consent, a physician proposing a course of treatment or a surgical procedure has a duty to provide the patient with enough information about its risks to enable the patient to make an informed choice. If an undisclosed risk was serious enough to a reasonable person in plaintiff's position to withhold consent to the treatment, then the doctor has breached this duty. Trespass to land, interference with the right of possession of the land requires an active physical invasion of the plaintiff's property by the defendant, intent on the defendant's part to bring about physical invasion, and causation. One who is not in possession generally has no right to sue for trespass unless damage is permanent. Assumption of risk, voluntarily assuming known risk, such as the plaintiff knew of a risk and voluntarily proceeded in face of the risk. Extreme and outrageous as part of the definition of intentional infliction of emotional distress was exceeds all bounds of decency tolerated in a civilized society. Mere insults are not outrageous. What can be is repetitive conduct, common carrier, innkeeper, or targeting known sensitivity. For instance, the plaintiff is part of a fragile class such as children, pregnant women, and elderly. Abnormally dangerous for strict liability torts is an activity that may be characterized as abnormally dangerous if it creates a foreseeable risk of serious harm, even when reasonable care is exercised by all actors. It's not a question of fact, but a question of law for the court. Pure comparative negligence as opposed to modified comparative negligence and contributory negligence. So I'll start actually the other way. Contributory negligence bars a recovery by the plaintiff if they are at fault. Pure comparative negligence, the jurisdiction allows the plaintiff to recover no matter how great their negligence was or how much they contributed to their own injury. And modified comparative negligence, a plaintiff cannot recover if greater than 50% at fault. If there's somewhere below 50% at fault, then there would be a reduction in plaintiff's recovery by the percentage of the plaintiff's fault. Merged causes. When two acts bring about an injury and either one alone would have sufficed, either of the acts is an actual cause of the injury if it was a substantial factor in bringing it about. Unascertained causes. When two acts bring When two actors were negligent, but it is not clear which was the actual cause of the injury, the burden shifts to each of the negligent actors to show that his negligent act was not the actual cause. Proximate cause. Oh my God, my neck is like destroyed. Limits liability for unforeseeable consequences of the defendant's actions. The defendant is liable for all harmful results that are the normal incidents of and within the increased risk from the defendant's actions. So what's foreseeable cause? It limits liability for unforeseeable consequences of the defendant's actions. Indirect causes: an intervening force occurs after the defendant's negligent acts and combines with it to cause the injury. Foreseeable intervening forces such as negligent rescue do not cut off the defendant's liability for the consequences of his negligent act. Supervening is also a cause. I wish I knew the definition, but I don't. Tends to come in a dialogue about, or with the dialogue about, intervening causes. So here you get the big cards. Trespass to chattel: intentional interference with plaintiff's personal property that warrants the defendant pay damages. Conversion: intentional interference with plaintiff's personal property so serious that warrants the defendant pay the property's full value, and that would be calculated by the fair market value at the time of the conversion. Vicarious liability: a defendant will first ask if the defendant can be liable for his own negligence, such as hiring and entrustment, and then next note that a defendant may be vicariously liable for the tort of another based on the relationship between the defendant and the tortfeasor. Example: employer-employee. By a theory of respondent superior, the employer is liable for torts of an employee that occurs within the scope of the employment relationship. There's the principal, independent contractor. General rule is the principal is not vicariously liable for the independent contractor's torts unless the independent contractor is engaged in inherently dangerous activities. 2. Plaintiff's duty cannot be delegated because the public policy consideration. Oh God, what? Yeah. Automobile owner and driver. An automobile owner is not vicariously liable for the negligence of the driver unless the state has adopted a permissive use statute or a family purpose doctrine. The permissive use statute is it creates liability for anyone anyone who drives with permission, but the family purpose doctrine is only any family members driving with permission create liability. Oh my God, my hair is so long. So, general basis of liability of a negligent infliction of emotional distress: the defendant breaches a duty to the plaintiff by creating a risk of physical injury, and the plaintiff suffers emotional distress as a result. It must be within the zone. A plaintiff must be within the zone of danger and ordinarily must suffer physical symptoms from distress. There's an exception. The defendant breaches a duty to a bystander not in the zone of danger who is closely related to the injured person, was present at the scene of the injury, and personally observed or perceived the event. There's another exception. A relationship exists between the defendant and plaintiff under which the defendant's negligence has great potential to directly cause emotional distress. The example given was hospital reports a death in the family member, but erroneously reports that to a member of their family. Compare and contrast this with intentional infliction of emotional distress, which is an intent to engage in extreme and outrageous conduct causing severe emotional distress. Recklessness is sufficient to meet the intent, and the severe emotional distress should be proven. I had it the other way around based on something that Barbary showed me. So just to prove you had emotional distress, but in negligent infliction of emotional distress, you also have to prove that there was a physical manifestation of the emotional distress. So maybe they're not even different at all. All right, so product liability, I've written I've covered this card with information, but the prima facie case is going to be established by determining that there was a commercial supplier who supplied a defective product, and the product was defective when it left the defendant's control, and it was reasonably foreseeable how the plaintiff would use the product, and the plaintiff suffered damages. So reading it the long ways is liability arises when a commercial supplier supplies a product in a defective condition unreasonably dangerous to its users. A product has a manufacturing defect when it varies from the other products in the manufacturing process and is dangerous beyond the expectation of the ordinary customer. I wrote in parentheses the customer expectation test. 2, a product has a design defect when all products of the line have dangerous characteristics because of mechanic features, packaging, or an information defect when users are given inadequate warnings and instructions, and a less dangerous modification or alternative was economically feasible. So there's a feasibility test for this that you'll analyze, which I didn't get the definition for, but I know that it is somewhat going to state that, say, for alternatives were feasible, that wouldn't greatly affect the price and utility of the product. So warranty is another theory for product liability recovery, and so is negligence. So in a negligence action, the prima facie elements are the same, and breach of duty shows negligent conduct that led to supplying defective product to the plaintiff. Strict liability is also a theory of products liability, or to recover in product liability, and the prima facie elements are that the liability arises from supplying a defective product, even if due care or no negligence or no opportunity to inspect, and only requires the product was defective when it left the defendant's control. Obviously, there needs to be damages also. So those are your tort note cards. I was of the position that I may not even have to read the remedies outline because I have so many remedies note cards, I believe. Actually, as I say that, I totally don't. I thought I did, but they're actually sort of everywhere. Order is essential. Are these them? Yeah, this actually looks like them. All right, so for remedies, I'm not going to read the entire CMR. It looks like I have 2 different versions of the Convisor mini review. One of them is 25 pages long, and it looks like it's specific to California. And one of them Oh, that's the only one I have actually at this minute. The other one is an outline that I read previously, and I wrote like everything I read within the table of contents, and that outline was 72 pages long. I'm going to attempt to read this and maybe fill in with my note cards as I go. So you start discussion of remedies with tort remedies and your damages. Analysis begins with compensatory damages, which makes a party whole, substantially as good as if the injury had not occurred, is what that means. And standard remedy is money damages. And they're broken into general damages foreseeable from the injury and special damages not foreseeable from the injury. The requirements to recover are causal, foreseeable, certain, and unavoidable. Nominal damages and punitive damages and interest and attorney's fees are actually recoverable in addition to compensatory damages. For nominal damages, these vindicate or establish the plaintiff's rights even where no actual injury or loss occurred. The punitive damages is a punishment for willful, wanton, malicious conduct and seem to arise from intentional torts, but not negligent actions. Actions concerning the sale of corporate shares of stock may arise in punitive damages or may give rise to punitive damages. There is a due process limitation. The factors considered are reprehensibility. The rule of thumb is that there's no more than 10 times that the punitive damages are no more than 10 times the compensatory damages, and non-party injuries are not part of the calculation. I wrote a lot of notes within interest and attorney's fees. So prejudgment interest is from the time the debt is due if damages are certain, capable of calculation by statute, I guess. And statute is where you're going to get a right to interest and attorney's fees. So by statute, a plaintiff may recover attorney's fees, for instance, in a shareholder derivative suit. Now, the next big topical area of the table of contents is restitutionary remedies. This is part 2. This is meaning that the plaintiff has conferred on the defendant a benefit, and to allow the defendant to retain the benefit would create unjust enrichment. I almost forgot. I do have some note cards to define these things. So restitutionary damages based on the amount of the benefit to the defendant. That's really all I wrote about it. I think a lot of my note cards actually are from contract law or more than tort law remedies, but place non-breaching party in the same position he would have been had the defendant performed. So yeah, so this is compensatory damages, a definition as it relates to contract law. So so there's an introduction to restitutionary remedies, including restitutionary damages and replevin, claim and delivery. Replevin, I have a note card for this, but what I've written is recovery of the personal property wrongfully taken or detained. And that's a good place to start, actually. The plaintiff recovers possession of personal property, right to possess, and wrongful withholding, which is like the worst definition ever. So I defined it again. Here it is. Replevin. It's kind of long. Defendant wrongfully deprived or detained personal property of the plaintiff, and a buyer, example, can bring an action to recover the goods if the goods are identified to the contract and the buyer, after reasonable effort, is unable to secure adequate substitute goods. Circumstances indicate that such effort would be unavailable. And another buyer example, so these are obviously contract replevins. The section that we're in, torts, replevin would be like probably wrongful dispossession by a trespassed chattel. Here we have a buyer again, paid full or part for goods identified, and the seller is not delivered. In such case, the buyer may replevy if the seller is insolvent within 10 days of receiving the buyer's first payment, or goods for when the goods are for family or household purposes. And that's really everything for now on replevin. Moving on to ejectment, wrongful possession, ouster. Plaintiff seeks mesne damages. Constructive trust is to convey property wrongfully acquired by the defendant to the plaintiff. The requirements for constructive trust is title held by the defendant, and tracing doctrine is how you might trace the property wrongfully dispossessed from the plaintiff to the defendant by tracing, and there's a limitation. Unjust enrichment and inadequacy of legal remedy. So there's definitely a note card for constructive trust and equitable liens. I'm going to read here additionally, advantages over restitution at law. In the constructive trust is there's a priority over unsecured creditors, and the increased value of property will go to the plaintiff. The defenses to action to impose constructive trust include the equitable defenses of laches, unclean hands, or bona fide purchaser. I could read actually laches and unclean hands right now. Here's the equitable remedies of constructive trust. And first, you have to establish that there is no adequate legal remedy at law, which might be because the defendant is insolvent or the property is unique, and tracing is allowed, and the bona fide purchasers prevail over the plaintiff. What I've written here is equitable defense of sale to bona fide purchaser, and I've written that the increase of the property value impacts the plaintiff in constructive trust, but not the equitable lien. Interesting. I forgot to read here ejectment. Defendant recovers possibility of possession of real property, right to possess, and wrongful withholding. So now I've read that whole card, and I actually read just about everything on constructive trust. The constructive trust right often imposed because of fraud, abuse of confidential relationship, and promise causa mortis, like facing impending death. I was going to read the equitable defenses of laches and unclean hands. A party delays in bringing an equitable action. The delay prejudices the defendant, and unclean hands is when the party seeking equitable remedy is guilty of some wrongdoing in the transaction itself. So that probably is going to be conclusive on constructive trust, but let's just see. pretty much hit everything that I know to hit. The purchase money resulting trusts is a whole different section. And then equitable liens, equitable charge on property imposed by law to prevent unjust enrichment. The requirements is that the title, the plaintiff's funds used to improve traceable defendant's property, and to make such an allegation, tracing again is permitted, and a showing of an inadequate legal remedy must be made, such as, for instance, the defendant is insolvent. Now, comparing this with the constructive trust, where the plaintiff can choose either remedy and the plaintiff cannot seek a constructive trust, and the transfer to a bona fide purchaser is a limit to recovering property. So that's a whole bunch of stuff that they compare to the constructive trust, but I think the biggest comparison is that in a constructive trust, there was actually property title in the defendant's name that was procured from the plaintiff's property that was the defendant, unlawfully deprived the plaintiff of. And in an equitable lien, you're not going to have a delineated new asset resulting from the dispossessed property. You're going to basically have it going into a bank account that already existed, or putting a pool on a property already in the defendant's name, not buying that property with the pool. So that's the biggest difference to me, even though it's not here. So they compared on all these other things, election of the remedy. Obviously, you're going, if you have your choice, you look to see if the property has improved in value, in which case you're going to look for constructive trust. I feel that one of them may be able to foreclose on property and the other is just a lien. So I could be wrong, but if that's the case, then they could be different based on how quickly one can recover. And they're the same on the fact that if the property has been resold to a bona fide purchaser, it's not available for recovery from the bona fide purchaser, and where the plaintiff cannot seek constructive trust. Got it. Okay, so an injunction is a whole nother section in restitution, and I have a note card on injunction, but there's two kinds, and the actual, all right, I'm gonna read my definition, but the actual outline goes into it for 5 pages. So I have 2 different kinds of injunctive relief in my note cards, and I thought I knew everything at one time about these 2 things, and then I realized that I was wrong, and so it's actually a bit difficult for me to understand how these are different. So number 1 is the TRO, the temporary relief order. Temporary restraining order. So to prevent your reparable injury by any delay, this is something that you would go to the court for in an exigent circumstance. Provide the court the reason for the justification that there would be irreparable injury for any delay, and give that time frame context, balancing the hardships. Basically, I don't really speak to what it is yet. So these are just the elements. Let me read preliminary injunction. Both of these do the same thing. They preserve the, quote, status quo until trial on the merits is held. And in the TRO, to preserve the status quo, this would be done by way of asking the court to order the opposing party to do something or not to do something. So, get that here. But in asking the court for such an order, you need to demonstrate irreparable injury, giving this time frame context and balancing the hardships between, like, not rendering the order on the plaintiff and rendering the order on the defendant, and balance out those two hardships, and then also provide the plaintiff's likelihood of success when the trial on the merits is held. Also there's bond requirements that the court may ask the plaintiff to provide. Sometimes it's probably like statutorily demanded, but you would pay a bond in the amount of how much the defendant might stand to lose if your suit is like without merit. Now, the preliminary injunction happens after the TRO, because the TRO, at least in California, it can go from like 14 to 21 days or something, at which point you'll probably have a preliminary injunction, which preserves the status quo until trial on the merits is held. It requires a showing, again, of irreparable injury if the plaintiff is not, or if the preliminary injunction is not granted. The harm outweighs the harm to the defendant from issuing the preliminary injunction, which is, again, the balancing of hardships, and then the likelihood to prevail on the merits. So you see how these are the exact same elements. It's really messing me up because I'm told that they're very different. And it's not just on when and for how long relief is granted. So I'm going to read this outline real quick. Injunctive relief in tort. It doesn't specifically say if we're talking about a preliminary injunction or TRO. It gives the introduction, identification of the tort, inadequacy of legal remedy as like the first element to establish, and the background of the requirement, reasons why the legal remedy may be inadequate. Money damages are inadequate, damages are too speculative, multiplicity of suits, continuous, no. I don't know what that means. I don't know what that says. Just irreparable injury, prospective tort, and uniqueness of, say, for instance, the asset at issue. So, example being that you have this agreement with someone to sell some ancient relic that's really expensive, and at the time that you contracted to sell it, they had no idea what it was worth, and we're going to give it to you for like nothing, and then broke their promise. And because they were like, why didn't you tell me that this is like a priceless $1 million artifact? And you're a liar. I'm going to sell it to someone who's going to be $1 million. And that person, having the person who didn't breach the contract, but maybe concealed or didn't represent any information about true value, that person has a lot to lose because maybe they're a collector of that ancient artifact and they can't get another one anywhere throughout the world because everyone who owns them won't sell them. So that was one of the case examples of, like, say, for instance, the uniqueness of the item demands that you bring this to court and have the court, like, order that the breaching party not sell the item to someone else before they can go to trial on the merits. That would be that example. And that would be more than just uniqueness. It also would be money damages maybe are inadequate because you can't get another one. Irreparable injury maybe because of whatever. That particular fact might meet several different elements. So ultimately, the requirements here is one. The requirements of the preliminary injunction, I think, require one thing that the TRO did not. So there's inadequacy of legal remedy. See, here I have irreparable injury. That's part of inadequacy formulation in my outline. Not sure why, but anyway, feasibility of enforcing the decree. I believe that would maybe be something that applies to the preliminary injunction. It didn't apply to the TRO. The balance of the hardships and the lack of defenses. Again, going into latches, the doctrine of latches similar or comparison with the statute of limitations and application and unclean hands, which I had previously read also with respect to the same matter, i.e. fraud, illegality, and tort doctrine. Actual tort not required. So let's go back to feasibility of enforcing the decree. The methods of enforcement: A, decrees ordering payment of money; B, parties and privies bound by the decree; mandatory versus negative injunctions, negative injunction, mandatory injunction. These are complex because you really have to frame very precisely the negative decree to avoid prior restraints like infringement of First Amendment rights. Feasibility of decree requiring acts in other states. Negative decree, mandatory decree are discussed again. Then we move on to balancing of hardships, approaches to them. There's a strict minority view and a liberal majority view. Within the strict minority view, there's only two sub-element or sub-bullets, one for encroachment cases, two for exception nuisance cases. Going to move on to defenses. I just read about latches and unclean hands. Defendant must not have profited, and that's from unclean hands. And limitation in use of defense. And then another defense is the interference with the freedom of speech. Because if you're telling a defendant they can't do something, like tell them they can't sell something, but tell them they have to, like, take down, like, their newsprint ad or, like, Craigslist ad, like, that's now an interference with freedom of speech. Injunction against criminal prosecutions, injunction against crimes. Constitutional problems within the injunctions against crimes and the public nuisance exception. Definition of public nuisance is an act or use of real property that endangers public health or welfare. Limitation on relief is expanded to crimes, unlawful practice of medicine, usury, for example, and private suits. Those are your public nuisance exceptions, subpoints, and then injunctions involving political or civil rights and the modern trend. We move to a different section called interlocutory injunctions, which are imposed for pendency to preserve the purpose of preserving the status quo. Requirements is that irreparable injury would persist if the if the injunction is not granted. Sufficiency of harm and timing. For sufficiency of harm, I've written balance hardship and preliminary injunction, not ex parte TRO. Likelihood of prevailing, notice, strong showing why notice should not be required, and exceptional circumstances, ex parte TROs, and damages bond requirement may limit recovery to reimbursement and join party if preliminary injunction improvidently granted. So, what this means is this section is meant to talk about the TRO, and you see how there's only 4 elements, which are the same 4 I probably spoke of: irreparable injury, likelihood of prevailing, notice, and bond requirements. So I'm going to add notice to my note card. Notice or a strong showing why notice should not be required. And then for preliminary injunctions now, in comparison, what you're looking to establish is an inadequacy of legal remedy, feasibility of enforcement, balance of hardships, and likelihood of prevailing on the merits. Both of them kind of prefer the absence of damages. Defenses. All right. If you can't remember what that stuff is, there's a mnemonic. I'm feeling bold and determined. So I'm as inadequate legal remedy. F is feasibility of enforcement. B is balance of hardships. And D is absence of defenses, equitable defenses. Now I'm going to move to application of remedies to specific torts. Intro, misappropriation of money, which is the wrongful appropriation of money in action for conversion. I got 2 parts here, 1 specific, 2 IID. Damages, restitutionary remedies, quasi-contract, constructive trust, specifically identified and traced, and equitable lien imposed on property, title of which was acquired with stolen money, commingled funds, limitation on recovery of funds deposited after withdrawal, and victim's option. So all of that is the same that I just discussed not too long ago, but they want to apply it to specific torts rather than just speaking of it in general. And injuries to personal property, destruction of chattels, damages, value is the value or the loss of use. For value, this is of chattel at the time of destruction minus salvage plus interest or value to owner subbed. Loss of use only if it's not meeting an exception. No, only if it's income producing property and or chattels are difficult to replace, in which case the recovery is for the rental value or the loss of profits calculation respectively, but like in the opposite. So income producing property, the loss of profits calculation would be applied. Chattels difficult to replace would be the rental value of replacement goods for the time that the true owner was wrongfully dispossessed of their chattel. Injury to chattels would be remedied by paying money damages of diminution in value before and after, or the cost of repair. And that's clearly not a conversion. That would be just the trespass to chattel recovery. disposition of chattel completely is a warrants conversion damages for major dispossession, chattels fluctuating in value, chattels retained by converter, chattels improved by converter, no duty to mitigate by accepting the chattel back if it's been so substantially altered, or you are entitled to replacement, and successive conversions and punitive damages. Malicious and outrageous is the standards for punitive damages. Trespass to chattel damages for minor dispossession, which is nominal or loss of use. Restitutionary remedies follows, which includes self-help, replevin, quasi-contract, constructive trust, and equitable lien. What I've written in self-help is that the owner of the personal property to use reasonable force to recapture from one who wrongfully obtained. And what I've written beside construction trust is only available if sold and the money is traceable. Now, mandatory injunction, unique chattel, and inadequacy of money damages. Like, for instance, if this is one of a kind or sentimental chattel, and replevin says sometimes inadequate, writ of seizure, and re-delivering bond, and due process limitations for the mandatory injunction in this trespass to chattel section. Injuries to real property, trespass to land, simple trespass has only nominal damages, but there's restitutionary remedies of two kinds. One is that there's no restitution in common law, and two is the modern law permits quasi-contract recovery. Injunctive relief for simple trespass. Enjoin a trespass is what I have written next to injunctive relief. Inadequacy of legal remedy, and restitution as ancillary remedy. For inadequacy of legal remedy, I've written multiplicity of causes of action. Trespass causing severance from realty, that's timber, mineral, and gravel. Damages is the diminution in value, treble or double if involuntarily caused. And restitutionary remedies is innocent. If it's an innocent severance, then pay the value of the severed property. Replevin and restitutionary damages are part of restitutionary remedies. For replevin, it's as improved without payment for improvement, and restitutionary damages. So what could that possibly mean? It's kind of like you've extracted gravel from my property, which is maybe worthless until you clean it or something, or put it through some type of a processing. So the recovery by replevin is going to give you your gravel back, whatever state it's in. Restitutionary damages, not innocent, equals the value of severed property of improved at time noticed and demanded. Injunctive relief, legal remedy is available. Letter B, lack of title is a defense. Trespass, so Part C in the injuries to real property is the trespass causing other injury. The damages are cost of removal of the debris or obstruction, or by the rental value. And the other part of trespass causing other injury is injunctive relief, and the legal remedy. You want to prove that the legal remedy is inadequate. Trespass affecting an ouster, ejection requires 1, the plaintiff's right to possession, 2, wrongful withholding by the defendant, judgment recovering mesne, and unlawful detainer below ejectment is forcible entry and detainer in residential rental. Mezzanine damages are good faith improvements by trespassers set off against mezzanine damages and betterment statutes. Probably govern that. No injunctive relief in trespass affecting ouster. Encroachments is the next section in injuries to real property. Encroachments is a continuing trespass resulting from one building structure partly on the plaintiff's land or invasions of airspace. The damages may include rental value of, if temporary, or market value if permanent. Restitutionary remedy of ejectment and injunction. All of the same elements of proving legal remedies are inadequate, and an injunction is impractical. You balance the hardships. Is a willful encroachment. That's relevant to this part of the analysis for injunctive relief, and the effect is private eminent domain ? Wrongful prevention and other factors, latches and public interest. Then there's destruction of or injury to realty, value of land before injury minus the value of the land after, destruction of buildings, value at time of destruction, reproduction minus depreciation, money value minus value of land, damage to buildings, cost of repair, destruction of trees and crops, diminution of value of real property, or separate value of crops apart from the real property, damage to underlying real estate, and then there's destruction or interference with easements, diminution in value of plaintiff's property, where EM attached, that's easement attached, and the damages include destruction and interference. Interference, I've written punitive damages is if conduct is malicious, and there's also injunctive relief for the destruction or interference of easements, requiring a showing that damages are inadequate for loss of property right, easement is legally recognized, and balancing the hardships. Waste, voluntary, permissive, and ameliorative are here, and nuisance follows. So what I'm going to say about waste. It's an act committed by one rightfully in possession of realty that does permanent injury to the land and harms future remaindermen. Voluntary waste is deliberate. Damages are a diminution in value before minus after injury or cost of repairs. Injunctive relief, prohibitory injunction available. Permissive waste, omission, neglect, for instance, and or that's actually the definition. The damages is the cost to repair, and injunctive relief is rarely granted. For ameliorative waste, I just wrote for a definition alter, but I do have actual definitions I'm going to read in a moment. The damages are generally not recoverable, and there's injunctive relief. Equitable waste, there's no remedy at all. Material change in freehold by tenant who is not chargeable, and the only thing under that section is injunctive relief. So let's read about waste. I put it in my real property note cards, but Might be in like the tenant's rights and duties, might be what it's actually called. Duty to pay rent one. Here it is. All ordinary uses and profits from the land do not commit waste. Voluntary, actual overt conduct causing a drop in the value. Permissive, failure to take reasonable measures to protect the land, i.e. neglect, and ameliorative, unilateral change that enhances the value. We're going to read about nuisances. Nuisance. This doesn't interfere unreasonably with use and enjoyment of another's property. The definition for public is affects the entire community or neighborhood, considerable number of people. Interference with easements is a wrongful interference with equiporeal rights, water, profit, etc. Damages can include, by the traditional rule, the rental value or loss of profits and costs to abate the nuisance and award for discomfort, I think that says. And when measured is at commencement of the action, and future damages are not recoverable. For a permanent nuisance doctrine, a physical permanence demonstrating nuisance cannot be practically abated will I think you're going to say here you're going to compensate a permanent diminution in value. Injunctive relief, legal remedy inadequate. I was talking about multiplicity of suits and irreparable injuries. So yeah, so they'll just give you like a one-time lump sum to try to pay you off. From complaining about the permanent nuisance rather than continue to have you come into the court and complain about one another's conduct. Balancing the hardship is another part of the injunction calculus. And within balancing of the hardships, you have 4 parts: balancing permitted, balancing rejected, the rationale. Conditional relief is 3rd, and 4th, defendant is a public service or municipal corporation. And lastly, coming to the nuisance is no defense and may allow the plaintiff to pay defendant to move. Injury to personal interests. This and fraud is going to be the last part before business torts and then going into contract remedies. So I want to do like a clean break between torts and contracts, but I'm putting literally myself to sleep. Let's do it. Injuries to personal interest, personal injuries. There's no restitutionary remedies. Personal injury tortiously inflicted, resulting in no economic benefit to the defendant. That's why there's no restitutionary remedies, because there's no economic benefit to the defendant. Injunctive relief is rarely even sought. Damages tend to be compensatory and are special or general. For special damages, these include economic losses such as medical expenses, past expenses, future expenses, loss of earnings, past earnings, future earnings, work expectancy, lost productivity, no earnings history, and shortened life expectancy. So for no earnings history, I've written probable in the margin. For shortened life expectancy, not a separately compensable element of, I don't know what that says. So computing the award, simple lump sum at present value. So there's discounting, there's no inflation, and no tax calculation. So it's not subject to the federal estate income tax. Non-economic losses, general damages include pain and suffering, emotional anguish, and loss of enjoyment or life. Pain and suffering is past, present, future pain and discomfort from injury. Emotional anguish is resulting from disability or disfigurement. Limitations on amount of damages is to voidable consequences. Collateral sources rule, insurance, and control. So I just wrote those things to be aware of. Survival of a tort action. Establish or state permitted to sue for personal injuries accrued up to the time of death. The measure of damages is the medical expenses and loss of earnings. The wrongful death actions include damages accruing after death. Defamation, whole different direction. Damages, I've written there's no restitutionary remedies because there's no gain to the defendant and generally no injunctive relief, freedom of speech rationale, and declaratory relief. Best remedy to protect interests and person's reputation is probably to get them to like publicly apologize or recant what they've published. And privacy, tortious invasion of privacy, mental anguish requires proof of malice. Damages, and note there's no restitutionary remedies but there is injunctive relief, and you'll argue the inadequacy of the legal remedy for injunctive relief. Fraud is the next section. Actual injury to establish fraud and proof of pecuniary loss, consequence, punitive maybe consequential damages. I don't know if that's what I mean by consequi, and punitive damages where malice is shown for the fraud. And other damages, fraud by a seller. There's a benefit of a bargain rule of valuable contracted for an actual value, value contracted for an actual value, market value he would have received. That's probably the benefit of the bargain rule. Gives you that as a figure. And then the out-of-pocket measure is the payment minus the value of that which he received. And the choice of the plaintiff in contract or tort is up to the plaintiff. Fraud by buyer and collateral fraud must be proximate. Restitution, including rescission and constructive trust. For rescission, what I've written here is party induced to enter contract by fraud, misrepresentation can 1. Affirm and seek damages, or 2. Rescind contract and seek restitution. Then we get to business torts, which is an intentional interference with the right to carry on lawful private enterprise. There's inducing a breach of contract, and there's a contract remedy tort measure of damages. Example, all injury approximately caused, mental suffering, reputational damages, punitive damages if willful and malicious. Other restitutionary damages and the benefit to the tortfeasor, only if repetitive. I've written here for injunctive relief, it's rarely granted. I put in parentheses profits. That might have something to do with the restitutionary remedies, though. So, like, I own a restaurant and a shopping center, and there's like 2 other restaurants, and I majorly defame the other restaurants as being like horrendous. They poisoned me, and then I get to reap the benefit because everyone comes to my restaurant that week. And so for restitutionary remedies, I may be forced to give up my profit. I don't know if that's the example, but interference with prospective advantage. I didn't read about the adequacy of other remedies, not applicable if injunction applies to third-party tortfeasor. So, in the interference or prospective advantage, damages are speculative and restitution may be appropriate. So, when the damages are speculative, property right deprivation, not a hope or expectancy, is a requirement. And then the restitution may be appropriate. So, an alternate remedy to recoup benefit to the defendant. Now, trade libel, which is defamation directed to plaintiff's business or product, is a statement disparaging the plaintiff's business, product, services to persuade clientele to not to do business. Special damages required is loss of particular customers, which leads to consequential damages. And historically, injunctive relief was denied, but the exception is libel occurs in conjunction with another enjoinable tort. Yeah, so that's why it was previously denied. I.e., unfair competition would be an example of one, or trademark infringement, coercion, intimidation. Those are all reasons why historically injunctive relief was denied. So now the modern trend is probably allowing injunctive relief. And then we've gotten to the contract remedies. Starting on page 39, there's going to be about 30 pages of contract remedies and some note cards that I can read to supplement this outline.